water to your left. And if you wouldn't mind, after you're seated, bringing that microphone closer to you so it picks up your voice. All right, counsel.
Thank you, Judge.
You're ready.
Good afternoon.
Afternoon.
Would you please state your full name and spell your last?
David Hull, H-U-L-L.
And are you employed?
I am, yes.
Who are you employed by?
I'm employed by the Department of Public Safety.
And how long have you worked for the Department of Public Safety?
I'm in my 12th year.
Are you a peace officer?
I am, yes.
Are you post-certified?
I am, yes.
When did you receive your certification?
2015.
And since that time, has your certification remained intact? In other words, has it lapsed or been taken away or anything like that?
No, it's been continuous.
You, I think you said you're in your 12th year. Did you already say that? Your 12th year with the DPS. Have you worked for any other law enforcement agency besides the DPS?
No, just the state of Utah.
What is your current assignment with the Department of Public Safety?
Currently positioned as an investigative sergeant at Peace Officer Standards and Training.
Was that your assignment in September of 2025?
No, it was not.
What was your assignment then?
I was under the State Bureau of Investigations, Major Crimes Division as an investigator.
Okay. Is SBI an acronym that's commonly used to describe the State Bureau of Investigation?
It is, yes.
I can refer to it as the SBI, and we're all on the same page, right?
Yep.
Okay. How long were you with the SBI?
A little over 7 years.
And what exactly did you do? What was your assignment with the SBI?
I spent just under a year in the Alcohol Bureau and the undercover unit, and then the remainder of that time was with Major Crimes.
Major crimes. What did that entail?
Predominantly investigating crimes that are considered to be major in nature. Predominantly violent crime, including homicide, sexual assault, in some cases fraud cases. Kind of covered a whole gambit of things, but predominantly violent crime.
And throughout your career with the DPS, have you done any training related to murder investigations specifically?
Yes, I have.
And could you just briefly describe what that specific training entailed?
I've done internal and external courses around lead homicide investigation, officer-involved critical incidents, child deaths and unexplained deaths in children, aquatic homicide, and then just continuing investigations related to homicide itself.
And throughout your career with DPS, have you either played a role in or led a homicide investigation?
I have, yes.
How many do you think?
Either directly or indirectly, I've probably been involved in approximately 40 or so.
And is that throughout the state of Utah?
Yes, we assist throughout the state of Utah.
Were you working September 10th of 2025?
I was, yes.
And did you work shifts? Did you work a certain shift that day, or how does it work at the SBI?
Kind of work 24/7, 365, but predominantly Monday through Thursday, office hours.
Okay. On that date, were you asked to respond to the campus of Utah Valley University?
I was, yeah. I was at the office in Taylorsville, and I was asked to respond down to Utah Valley University.
Okay. And what did you understand was going on at UVU that day?
I didn't know much. I had been told that there was some kind of an event and an individual had been shot.
Did you have a name?
Someone had told me that Charlie Kirk had been shot.
At that point in time, were you familiar with Charlie Kirk?
I was not, no.
Okay. Did you end up responding? So when you found out that there was an event, that it was Charlie Kirk that had been shot, that was while you were still up in Taylorsville at your office?
Yes, we hadn't been asked to respond at that point. Another agent in the office showed me a video of the shooting, and I went back to work because we hadn't been asked to respond at that point.
At some point, though, were you asked to respond or directed to respond to Utah Valley?
Yes, we were. We were asked to make our way down to the university to provide any kind of assistance that was needed.
Okay. And do you recall who directed you to come down to Utah Valley?
I believe it was Lieutenant Jensen.
And is that something, responding to a scene like this, on a report like that, is that something that's done frequently within the SBI?
Yeah, SBI functions as a supplementary investigative division for really anybody in the state who needs it, whether it's a smaller local agency that just needs additional resources. We often respond with the crime lab to help process crime scenes. But it would be normal for us to be called out to assist another agency.
Okay, so we understand correctly, when you were first directed to come down to Utah Valley, you were just coming down to give whatever help you could provide.
Correct.
Okay. That eventually changed.
Yes, yeah.
Okay.
My assumption
Well-
was we were responding to assist process a crime scene, essentially.
Prior to September 10th, 2025, how familiar were you with the Utah Valley University campus?
Not very. I think I maybe had been there once before.
How about from September 10th onward? Did you become more familiar with the campus?
Became a lot more familiar with the campus, yes.
And in what way or how?
Both in walking the campus and looking at the incident scene, in viewing surveillance video of the campus and the surrounding areas, and just my general involvement in the investigation. I became a lot more familiar with the buildings, the amphitheater and the surrounding area, and the campus itself.
All right, and we'll come back to that here in a moment. Who else responded to UVU from the SBI?
Originally, I thought it was just myself and a couple of others. I remember Sergeant Falmina, Sergeant Bricker, Sergeant L. Schultz, Sergeant Clark, Agent Brian Davis, and a number of other agents were arriving or were on scene when I arrived there.
Do you recall if other law enforcement agencies responded that same day?
Yes, there was a large law enforcement presence. Federal entities, I believe the FBI, the DEA, ATF, I think some U.S. Marshals. There was obviously our state presence, and then there was county and city and local agencies on scene also.
So had all these folks responded by the time you got here, or had they responded prior to, or?
Some could have been on scene prior to, some were arriving while I was arriving, others arrived later. I know there were several forensic units from various entities, including the State Crime Lab and other agencies.
And did you interact with all these different agencies? You personally?
Throughout the course of the following few days, probably the majority of them, yes.
I think you related that originally the SBI was directed to come down just to see if you could help. Is that fair to say?
Yeah, that was all I knew when I left the office, was that go down and see what services, what can you do to help.
And I asked you earlier if that role changed, and I believe you said it did.
Mm-hmm.
So let's talk about that. How did your role change from what you initially came down to do to whatever it evolved into?
Having been on scene for a little while, there were some conversations and discussions that took place. And I was informed by my lieutenant that myself and Agent Davis would be taking lead on the investigation on behalf of the State Bureau of Investigations.
So the SBI was going to be the lead investigative agency,
Correct.
and you were going to be the lead case agent,
Yes, sir.
along with Agent
Davis.
Davis.
Yep.
Okay. What does it mean to be the lead investigator or the lead case agent?
It depends on the situation, but predominantly you're responsible for kind of directing the investigation, coordinating information that is coming in. Typically, scenes are fairly chaotic initially, so you're trying to process as much information as possible and make as much use of the available resources that you have. Kind of an organizational role would probably be a good way to describe it.
Okay. So you played an active role in organizing.
In coordination with the administrations of all of the agencies that were on scene, yeah, we were trying to coordinate efforts and get to pertinent information as quickly as possible.
Do you recall whether assignments were made, at least with the SBI agents that responded with you?
Yeah, we have a core group within major crimes that were assigned specific tasks.
Okay. And do they include the agents that you mentioned just a minute ago?
Yes, I believe so.
So each one of those agents with the SBI were given a specific assignment?
Yes, with the information we had, the agents were assigned to do specific things.
And do you remember specifically what assignments were given to whom?
Yes, Sergeant Falmina was asked to coordinate with the State Crime Lab and the responding crime scene techs to manage and process any identified crime scenes. Sergeant Mark Bricker was put in touch with UVU's surveillance and operations team to start working through any available footage or information that we had that had been recorded. Sergeant Clark was tasked with the area canvas around the campus area, looking for information or any available information from the immediate area around campus. Sergeant L. Schultz was working with the SIAC and other administration to try and manage the flow of information that had started to occur.
Okay. You said that initially when you showed up, things were a bit chaotic.
Yes.
Did that have something to do with all the different agencies that had responded?
Yes, and I think initially there was still some uncertainty as to whether we were working with an active shooter or an active crime scene. The campus is spread over a large area, and so getting that deemed to be safe is quite a process and involved a lot of people.
Gotcha. Do you know if the campus was deemed safe eventually?
Eventually, my understanding is the campus was locked down and secured, and we were able to start getting people in to start processing crime scenes and doing additional things.
Okay. You said it sounds like that chaos eventually subsided. You got organized and assignments were made. What was the first thing that you did as lead investigator?
It kind of became organized chaos, but we did have a plan, and our priority was determining whether we had an ability or a way to be able to identify who had been involved in the shooting.
Okay.
That was our primary focus at that time.
Did that include collecting information that was becoming available?
Yes, we were getting a large volume of information from the general public, phone tips, people sending videos. Analysts were scrolling through social media and social sites as people were posting information onto the internet. So there was a lot of information coming in, a lot of things that needed to be processed through and worked.
Okay, were videos coming in?
Yes, cell phone videos were coming in. If you imagine there's 3,000 people at an event and everybody has a cell phone, there was a lot of information that people were willing to share with us.
Right. Do you know whether you or someone else with the SBI collected or received a video from an Amanda Wright?
Yes, yeah, I know a cell phone video was collected from Amanda Wright.
Okay. And do you know
Or Amber
who?
Wright.
I'm
Is it
sorry?
Amber Wright?
Oh, I'm sorry, Amber. Well, you tell me, Amanda or Amber?
Amber.
Okay, I apologize for that wrong first name. Do you know who or how that video was collected?
Yeah, I spoke with Miss Wright directly on the phone to arrange a time to go and collect that video. Unfortunately, she wasn't available that day, but Agent Davis was able to go meet with her directly and collect the video.
Do you recall what date you actually spoke to Miss Wright?
If I can refresh my recollection,
Well-
I specifically,
Sure, let me ask you this before you do that.
Yes, sir.
So you have in front of you what, your police report?
I have some notes and a timeline from my
Okay.
investigation that was part of discovery.
And referencing that timeline or those notes, will they help you recall the date that you called Miss Wright?
They will, yes.
Okay. Why don't you go ahead and refer to that? Don't read from it out loud. Just take a minute. Let me know when you've come across that information and once you've refreshed your memory.
Your Honor, when he's done, may I take a look at the materials as well, please?
You may.
Ms. Wright was contacted on April 7th.
Okay. Did you want
All right. Ms. Nestor, if you'd like to come forward,
May
you
I
may.
approach, Your Honor?
Yep.
Mr. Sturgill, when you go back, if you wouldn't mind shifting the lectrum to my right.
You're right.
Yes, it just appears when the camera's focused on you, just the way it's positioned, you're in front of the witness, and
Oh.
we just want to make sure that.
Yeah, it's only going to go that far, Judge.
All right,
Is that going to be far enough?
I think that is sufficient. So, all right, thank you. I appreciate your
Yeah,
help
I
with
did
that.
just check from the, are we still connected? Okay.
All right, let's make sure that Mr. Sturgill is picked up.
Okay.
All right, you may proceed. Thank you.
And if I could make,
So-
if I could make a correction to that, I think.
Well, let me ask you this first.
So he needs to ask you a question.
okay.
So, Mr. Sturgill.
So you've had a moment to look at your
Yes,
notes?
sir.
Did that help you remember the date that you contacted Ms. Wright?
It did, yes.
Okay. Why don't you go ahead and tell us what date you contacted Ms. Wright?
I contacted her, I think it was April 6th specifically, but Agent Davis met with her on April 7th.
Okay. Well, that was going to be my next question. So you actually talked to her was it on the phone?
It was, yes.
And did you arrange a time for either you or Agent Davis to go get the video from Ms. Wright? Is
Yes,
that how it happened?
yes,
And then you didn't go, it was Agent Davis that went?
correct.
Okay, gotcha. And what, if anything, has been done with that video in preparation for today?
My understanding is that some edits were made by your office in order to protect some of the participants in the video.
Okay. But what, let me ask you this. Did you or Agent Davis visit with Ms. Wright again?
Yes, that was in April, and that was where my correction was. The video was originally provided to Agent Mortensen.
Okay.
So I misspoke.
Okay, let's go back and let's make sure this is very clear.
Sure.
Okay. So, someone with the SBI collected a video
Yes.
from Amber Wright.
Yes, Agent Mortensen contacted Ms. Wright on October 8th, and a video was provided to him electronically on October 11th.
Okay. And now I'll ask the next question. What, if anything, has been done, either by you or another agent, with that same video in preparation for today's hearing?
We contacted Ms. Wright to arrange a meeting so that Ms. Wright could review the video and that we could verify firsthand with her that the video was what she had taken on September 10th at the event at UVU.
Okay. And who had that follow-up visit with Ms. Wright?
That was Agent Davis. I was not able to attend.
Okay. And you know that happened because you spoke to Agent Davis?
I spoke to Agent Davis, and he provided me with a written statement that Ms. Wright had completed
Okay.
at 11:02.
And so you have seen that written statement?
I have, yes.
Okay. And you've read through it?
I have.
Does that, do you recall whether that statement was on a form or a piece of scratch paper? What do you recall?
My recollection is that it was on an official, I believe, a State Bureau 1102 statement, which is a written form that is filled out by a witness that contains the 1102 warning.
And by that, do you mean the advisory, the statement that's written on that piece of paper is going to be used at a preliminary hearing?
Yes,
It includes that advisory.
yes.
Does it also include a warning that if someone provides a false statement, in this case, Ms. Wright, that it could be punishable by a Class A misdemeanor?
It does, yes.
All right. And what do you recall is the essence of that written statement from Ms. Wright? I mean, what does it basically say?
Object, Your Honor. At this point, we want to assert our standing objection to the constitutionality of allowing in Ms. Wright's statement when she is not here present in court to be cross-examined. We did include those constitutional arguments in our standing objection. Also, this does fall under the type of document that should be safeguarded under Rule 4-202.02, Parent 8, Parent F as in Frank, and or should be classified as protected under subsection 5O as in orange, because the disclosure could jeopardize the life, safety, or property of the witness. It's also technically of victims. I mean, if she's present under the current theory and the information, she's technically could be classified as a victim of the event. So it also should be protected under that. So we would object to it being read in public. It would not be admissible at trial in the current format that it is due to its hearsay nature. We do think it would negatively impact our client's right to a fair trial. And furthermore, I believe the witness herself has requested that, particularly because the video contains images of minor children, which I know the state has made an effort to redact, but nevertheless, the reference to the minors, I think, would still fall under the protection. And so for all those reasons, we would object to that coming out in public and being discussed in the public forum and being published in any way. And we object to it coming in.
All right, and so if you wouldn't mind just restating the rule that you're relying upon, so I can fully look at your objection.
It's the UCJA, the Utah, Code of Judicial Administration. I just blanked. The Utah Code of Judicial Administration for Rule 4-202.02, parenthetical 8, parenthetical F as in Frank, and or parenthetical 5 and parenthetical capital O.
All right, thank you. I'm just
Yes, sir.
getting there. I want to review this before I hear from Mr. Sturgill. All right, I've reviewed that, Mr. Sturgill.
Well, Judge, let me address, I guess, a couple of things. Ms. Nestor actually brought up, I think, both the 1102 statement that we intend to introduce and sort of referred to the video. So let me address each of those one at a time. With regards to the 1102 statement that was prepared by Ms. Wright, Judge, it was gathered in compliance with the Utah Rules of Evidence 1102, specifically subsection B8. It's a statement that was gathered by an SBI agent. It was prepared with knowledge of the advisory that it was going to be used at the preliminary hearing, and it also included the warning that if a false statement is given, it's going to be a Class A misdemeanor. Judge, I don't know what additional foundation you'd like. Well, that's kind of where I was going, Judge, is I was trying to lay a little bit more foundation just to introduce that statement alone. I haven't got yet to the video. But with regards to the 1102 statement, it has been collected in compliance with Rule 1102. As I stated, B3 or B8. And as we all know, Rule 1102 allows reliable hearsay, as does the state constitution, Article 1, Section 12.
So what exhibit will this be? I want to look at it not for the purposes of, as a magistrate, taking it into evidence, but see if it comports with Rule 1102 as stated, because I haven't seen it.
Sure.
And I haven't done the analysis to see if that objection is.
Judge, it is State's Exhibit 6.1.
And Your Honor, just for the record, we just want to make a record too that it's difficult for the court to make a reliability finding when the individual is not here to be tested and cross-examined. And for those same reasons that we list in our standing objection, we just want to reiterate to the court that we think it really hampers you from making that reliability determination.
Thank you. Anything further, Mr. Sturgill?
Well, just that 1102 doesn't require that, Judge. It doesn't require that the witness be here to corroborate the statement that they've already prepared.
All right. All right. I've had a chance to review State's Exhibit 6.1, taking into note what Ms. Nestor noted, UCJA 4-202.02 2.02 and referencing the section she did.
Well, and Judge, I don't mean to interrupt, but I had not yet addressed that rule. I would simply just add to that judicial rule, it has nothing to do with admissibility. It's simply publishing it.
Is it-
And, I'm sorry.
So, okay, so let me just hear your full
Yeah,
argument. so
I
that
didn't
can-
realize you wanted to hear all of it. I thought you were going to rule on the 1102, but.
Well, I want to focus on the 1102. I want to keep this clean. So let's
Right.
focus on the 1102
Right.
and we'll stop
Sure.
there and I can make my ruling. And then if there's any objections, I just need to take it one step at a time to be thorough. So
Sure.
I'll hear all your arguments about the 1102 statement. I'll return to Ms. Nestor for any final thoughts, and then I'll make my ruling, and then we can move to the next
I
stage.
appreciate that, Judge. And I think I think I have addressed the 1102 question. As far as admissibility under Rule 1102, I thought that's what you wanted to rule on first, and then I would address the UCJA 4-202.02. And if you want me to do that now, I can do that, and it's just simply that it has nothing to do with admissibility. It has everything to do with publishing that. And Judge, I think if you'll look at that written statement, I believe Ms. Wright's personal information, for the most part, has been redacted. Other
Well-
than that, and beyond that, Judge, I'll leave it up to your discretion.
Well, as it relates to, well, let me take it one at a time. Let's start with the last statement. What I have in front of me, Plaintiff's Exhibit 6.1, has her full information here: address, phone number, social security number.
Okay, Judge, I apologize for that. I thought we'd provided a redacted version of that. Yeah. I think I've clarified what's going on here. I think we provided you with an unredacted version some time ago. The version that we have and are prepared to present today is a redacted version.
Could I have a copy of what you're intending to admit into evidence so I can consider what's before me?
Judge, we can bring it up electronically. We don't have a hard copy of that.
All right, and I want to make sure that's not coming on screen. It's just coming
Yeah.
on my screen to review it. All right. Okay, no, and that's fine. It's not, it's just for my, that I can look it on my screen because I'm trying to evaluate, so if you just want to put it back on my screen. All right, well, so what I'm doing is I'm looking at this, and just for clarity, moving forward, if there is a particular exhibit, I'll ask that you provide it instead of me relying upon it here, just so there's no misunderstanding, and I can see exactly what is being moved into evidence. I don't want to assume,
Right.
and I want to do the proper analysis. All right, so
And I appreciate that, Judge, and I apologize. I understood that we were presenting redacted copies today, and
Okay.
I think there's
No,
just been
that's
a little bit of a glitch, so I apologize for that, Judge.
all right, and Ms. Nestor, I just want to make sure that you're looking at this exhibit as opposed to what I was just looking at in regards to your arguments. With this clarification in mind, any update to your argument or anything that you would like the court to consider?
The only other issue I think that exists with this that I haven't already raised is that there's clearly two different authors in the body of the document. One wrote something on the very top line, and then it looks like Ms. Wright wrote the rest of it,
Scroll down.
which we don't have any indication of who wrote that top line and when they filled that in, if it was before or after she signed the document. So I have some concerns about authenticity with respect to that as well, and that's all I have.
All right, and as I'm determining it, it does appear that the writing is different. Did you want to lay additional foundation, Mr. Sturgill,
Certainly,
or
Judge.
provide information for the
I'd
court?
be happy to do that. Do you have in front of you State's Exhibit 6.1?
I do, yes.
Okay. You've heard the discussion that just took place. It appears as if there's two different styles of writing on that form.
Yes.
Okay. I imagine that you have the writing that includes the personal information for Ms. Wright, and then directly below that, I think there's a line there that appears to be arguably writing prepared by someone else. Is that in fact accurate, that that is a different
That's correct.
author of that writing? What do you know about that writing on that first line just below statement of incident?
Because we were asking Ms. Wright to verify a specific video, the file name for that video was written on the statement in her presence. And then that video with that file name was then shown to Ms. Wright to verify that it was, in fact, the video that she had provided to us.
Okay. And so was it you or SBI agent Davis that prepared that?
Based on the writing, it appears to be Agent Davis's writing, but it's not my writing.
All right. But that is the routine, or is that kind of how you commonly do this?
In this case, because we were specifically asking them to verify a specific digital file that had a specific digital name, and we didn't want there to be any errors in how that name was presented, we wrote the file name on the document for the individuals.
Okay.
All right. Anything further, Ms. Nestor, with that additional information before the court makes its ruling?
Your Honor.
All right, thank you. And could you leave that on the screen for me, please? I appreciate that. And scroll down to the bottom. I just want to review it one last time. All right. And I believe this is Exhibit 6.1. Is that correct, Mr.
It is,
Sturgill?
Judge. And
Right,
I would move to admit 6.1.
Thank you. So considering the arguments made by Ms. Nestor and Mr. Sturgill, I rely upon Rule 1102 as well as the Utah Constitutional Article 1, Section 12, as I previously mentioned, that final paragraph. It states, nothing in this Constitution shall preclude the use of reliable hearsay as defined by statute or rule in whole or in part at any preliminary examination to determine probable cause or at any pretrial proceeding with respect to release of the defendant if appropriate discovery is allowed as defined by statute or rule. I have examined this and the clarification was made. The previous version of this would fall afoul of having identifiable personal information of Ms. Wright, and so that was removed, and this one with the redacted portion of the identifiable information, personal information for Ms. Wright is before me, and based off that, State's Exhibit 6.1 with redactions is admitted into evidence and may be published.
Thank you, Judge. Agent Hull, that statement that was prepared by Ms. Wright, what does it state with regards to the video that you showed her that day, or I guess Agent Davis showed her that day?
It states that she's confirmed that she did review the video and that it was a true reflection of the video that she took on September 10th, 2025.
And did she identify who's in that video in her statement?
Herself and her 2 young children.
If we could just have a clarification on the court's ruling. So I understand the court overruled and published, and I accept the ruling, but I thought under the court's previous order that the media was not going to film exhibits. And they are filming the ones that are on that screen. So I guess I just need to clarify that, Your Honor. I'm sorry.
No, and I appreciate the clarification. It's important. What my ruling when we came back from break was if you're objecting specifically to the exhibit and then to the exhibit being published in the courtroom and then the exhibit being published which can be captured by media, if that's not specifically addressed, I am going to allow it. So I didn't hear a specific objection to that. So I appreciate you bringing that up, but that's how I'm looking at every single objection, just for clarity of the record.
Thank you, Your Honor. So just to make sure I correct the record, we are objecting to the publication of this under the UCGAA rules for the reasons I said, but I respect that you've ruled on that. And in the future, I guess we'll just make particularly clear we're objecting to publication because I do think anything that's getting on that screen is getting filmed.
Okay.
So thank you, Your Honor.
Thank you, Ms. Nestor. And Mr. Sturgill, did you want to respond? I mean, it's the genie's a little bit out of the bottle on this particular issue, but any record you wish to make.
Judge, we're simply going to seek to admit each one of these exhibits, and then we're going to leave it up to Your Honor's discretion whether to publish them beyond well, to what extent you want to publish them.
All right, well, I would prefer argument on this issue from both sides. I don't, this is the burden of the state, so I don't want to exceed my lane by just assuming. So I'll leave it to you to make the argument what you're requesting.
Sorry about that.
So before you're moving on, Mr. Sturgill, as it relates to
yes.
this, I want to put this to bed and then we can move on. Were you requesting for it to be published on, so the three, you moved it into evidence, which I approved. It is moved into evidence, but I didn't hear anything in regards to publishing to the courtroom and then lastly publishing, which it would be captured by the camera in the background, in the back.
Judge, we believe these are public documents, and so we would ask that they be published both to the audience and to the public at large.
All right. Well, given that we've gone past the gate on this one, it's been published.
Right.
But I think we're all on the same page in regards to how objections may be made and how the court is going to consider it, so we can move forward. All right. Thank you, Mr. Sturgill.
Thank you. Have you personally watched Miss Wright's video?
I have, yes.
Right. And what is depicted in that video?
It's a view of Ms. Wright's position in the crowd at the event on September 10th.
Okay. And absent the written statement from Ms. Wright, can you at least recognize the location that's displayed or depicted in this particular video?
Yes, it's the amphitheater at the Utah Valley University where Mr. Kirk was doing his event.
Okay. On your screen, Exhibit 6. Do you see anything on your screen yet? Just the very beginning.
It's there now.
It's there now. Do you recognize what's depicted on your screen right now?
I do, yes.
And what is that?
In the background is the Hall of Flags, and then you have the gazebo under which Mr. Kirk was presenting his event from, and then the crowd between where Ms. Wright was and the stage.
Okay. But do you recognize what this is the beginning of?
Yes, this is the beginning of Ms. Wright's video.
Okay. Judge, the state would move to admit what's been marked State's Exhibit 6.1. Oh, I'm sorry, 6. I apologize.
And to what level? Hold on, Ms. Nestor. I just want to get the clarification, and then I'll certainly turn to you. So the levels of admitting into evidence, then the next level is publishing it to the courtroom, and then the next level is publishing it in a way that is captured by the media. What is your full request?
Judge, we'd ask that, first of all, it be admitted, that it be published here within the courtroom, and then that it also be published to the public at large.
All right, and I'm not quite sure what this particular video is showing. Could you lay a little bit more foundation or proffer that what this is?
Sure. You've seen this video, Agent Hull?
Correct.
What's depicted in this video?
The crowd and the beginning of Mr. Kirk's presentation to the audience in the amphitheater at UVU on September 10th, 2025.
Okay. Does it depict Miss Wright?
I believe towards the end of the video it scrolls back and Ms. Wright shows the people that she's with at the event and herself, yes.
All right, is there any act of alleged violence in this particular
No,
clip?
there is not, Judge, but there is not.
Okay, I just needed that clarification. Ms.
Right.
Nestor, I'll turn to you. I just wanted to make sure I understand the full scope of this exhibit and then hear from your objection, if any.
Your Honor, with respect to admission, we object to its admission on the grounds that it's not properly authenticated, as Ms. Wright herself is not present in. For all the constitutional reasons we raised in our standing objection, we object to that. As far as its publication, we object to its publication. It definitely is something that in its current form without her here would not be admissible in any place other than a preliminary hearing. And we feel like this would really impinge on Mr. Robinson's right to a fair trial. And so we're asking it not be published, and certainly if the court does publish it, that it certainly not be filmed.
Thank you. Mr. Sturgill, any response?
Judge, Rule 901 addresses authenticating or identifying evidence to satisfy the requirement of authenticating a document, or I guess authenticating a piece of evidence. The proponent, which in this case is the state, must produce evidence sufficient to support a finding that the item is what the proponent claims it to be. And then the rule goes on to explain or provide examples of how this rule can be satisfied. And at the very top, under subsection B1, is testimony of a witness with knowledge. That goes on to say that testimony that an item is what it is claimed to be satisfies this authentication rule. Judge, you have an 1102 statement prepared by the person who actually caught these images on her camera or on her phone, and so, Judge, I think that alone sufficiently authenticates the document. And then even further than that, you have Agent Hull, who has reviewed the video himself and authenticates it, at least with regards to location.
Thank you. As it relates to admissibility of this exhibit, I believe this is State's Exhibit 6, is that?
It is, Judge.
All right.
Your Honor, I'm sorry to interrupt. Can I add one more thing just for the record? For purposes of publication question, under UCJA 4-202.02, parent 4, parent R is in Richard, photograph, film, or video of a crime victim are designated as private court records. And I do think that based on what the state has previously referenced, they are perceiving that everyone in the audience is a potential victim, and so we think it shouldn't be published under that rule.
Thank you. Mr. Sturgill, on that final point.
Judge, I appreciate that argument from Ms. Nestor. And we don't necessarily disagree, but to that end, to protect who we believe is a victims in this video, I believe their faces have been blurred out.
Oh, I see. Ms. Nestor, have you?
I think it's only the minor children whose faces are blurred out, not Ms. Wright, if I'm not mistaken, unless it's been subsequently altered.
My recollection is they've all been blurred out.
All right, I need to view this again, so let's just put it on my monitor. Again, I'm just trying to make sure that in order for make a ruling on this, I need to view it. So let's put it on my monitor, play it without any sound. Okay, my understanding is the prosecution has control of this exhibit, so what I'm asking is that the sound be turned off, if there is any, and just go ahead and play it, and it's only on, well, it's on all the parties' monitors, because I want you all to view it, because that can go directly to, as you've mentioned, Ms. Nestor, whether it's possibly admissible. So let's go ahead and play that. All right, thank you. Based off what I've watched, there was some blurring of faces, but not of all the faces, and so I'm going to rule that it is admissible. Sure, I'll wait until all parties are ready to proceed. So anything further? I just want to make
No,
sure.
Judge, you've had a chance to watch that.
I did. So I'm ruling that it is admissible into evidence, again, taking into consideration the analysis the court's talked about in regards to 1102s and this particular piece of evidence as it relates to the 1102 video, the 1102 statement 6.1. And I'm going to allow it to admit it into evidence. And because the faces of the alleged victims are not all obscured, there are some that are visible, it's not going to be published to in-court monitor and obviously not to be filmed by the media. So the court will receive it into evidence. The court will watch it again right now, and then we can continue to proceed.
Very good. Thank you, Judge.
So if, to the state, if you would like to play it again for me, I'm viewing it as it relates to consideration as the magistrate.
Your Honor, sounds like an issue that's going to come up again. I represent the news media. Can I be heard on this issue?
Yes.
I just wanted to address it. I've tried to be quiet. I just wanted to address it now because it's going to keep coming up, it sounds like. The classification rule that Ms. Nestor is citing and that Your Honor was just reading is not about in-court exhibits. That is classification for records in the court file. So it is a fundamentally different thing when we are in a public proceeding and the state is presenting an exhibit that you are relying on, and the public is being denied the chance to see it. That is a fundamental violation of the right of access. And it's a qualified right, and I recognize that. But that's not the ruling that you just made. You're just ruling based on the Code of Judicial Administration, which doesn't have anything to do with when something is presented in a public proceeding. So while I recognize there are certain things where I understand that you were going to make an exhibit-by-exhibit evaluation based on certain exhibits that may, be somewhat, may cross the heavy threshold of being so prejudicial that they cannot be shown in public, that is not this. And so I just wanted to make clear that the things that are in Rule 202 are not, when it is presented in open court as an exhibit for you to rely on, the public is entitled to see what you're seeing so that they can understand what your decision-making process is. And so this one, it doesn't sound like, this sounds pretty anodyne to me. It's not even depicting the shooting. I just wanted to clarify that the classification issue about when, we're filing things with the court and we say like this, maybe we file a motion to classify. That's not the decision that you're making today. The decision you're making today is the state is presenting something to you. You're watching it. You're making a decision based on it. And the people in the gallery have the right to see that. Whether you allow EMC of it is a different question. And we think that the EMC should be allowed to for reasons that we briefed. But I do think that it at least should be published to the courtroom.
Thank you.
Thank you, Your Honor.
To the parties, do you wish to respond?
State is not. We'll submit it. Well, Judge, I'm sorry.
Oh, hold on. Okay, so
I'm sorry.
we'll go to Ms. Nestor first
ahead.
and then to the state.
No, Your Honor, thank you.
Mr. Sturgill.
The only other additional observation I'd make is with regards to this video and this video only, the state doesn't believe that the defense really has standing to make an argument on behalf of the victims in this case.
All right. All right, based off of what's been presented in recognizing the argument from the media, I see the differentiation and how they are differentiating the rule that was cited versus what was presented. So I'm going to go ahead and rule that this may be played in the courtroom, but not be captured on video. So to the camera operator, I just want to make sure that it's going to be playing on that, but I don't want it captured. I appreciate the patience of the parties as we're going through the many layers that need to be addressed on exhibits such as these. So we'll go ahead and, once that's ready to be played, let's go ahead and do that.
That's a lot of people, Utah, I'll tell you what.
Order.
Here's
Alice?
everybody. You know how it works.
Thank you, and that concludes Exhibit 6.
Correct, thank you.
Mr. Sturgill, you may continue.
Agent Hull, did you or any other SBI agent collect additional video?
Yes, there were other videos collected.
What additional video did you collect?
A cell phone video from Mr. Phillips was collected.
And do you know who or how that video was collected?
Yes, Agent Schultz made contact with Mr. Phillips September 29th of 2025, and that video was provided to him. Subsequently, in preparation for the proceedings today, myself and Agent Davis met with Mr. Phillips on April 6th, and he completed an 1102 and went through the same process as Ms. Wright. The only difference being on this occasion that because he is a minor, his mother witnessed it and also signed a statement.
Okay. So you personally reviewed Mr. Phillips's video with Mr. Phillips?
Correct.
Okay. And you had him prepare a written statement?
Yes, correct.
Okay. Again, on this written statement, are there two different authors?
Yes, I believe in this instance it was myself that wrote the file name on the form.
Okay. And so you wrote, what part of the statement did you write?
Just the name of the file that we were asking Mr. Phillips to verify.
Okay. I'm going to have exhibited on your screen what's been marked States Exhibit 7.1. And this should just be for Agent Hull.
That's on my screen.
Is it on your screen? Do you recognize what that is?
I do, yes.
What is that?
The State Bureau of Investigation 1102 form completed by Mr. Phillips.
Okay. And did you gather that from Mr. Phillips?
I did, yes.
And again, does this statement include the advisory that is going to be used in lieu of his testimony at prelim?
It does.
And does it also include a warning that if he makes the author makes a false statement, that it could be punishable by being charged with a Class A misdemeanor?
It does, yes.
Okay. Anything about this exhibit look different than the day you collected it?
No.
Justice State would seek to admit Exhibit 7.1.
Ms. Nestor?
Thank you, Your Honor. We would object to the admission on the grounds that this video does in fact show a close-up view of the shooting of Mr. Kirk and grievous injuries in very stark relief. And because of that, we are particularly concerned about our constitutional claims we have made and our standing objection in terms of our ability to get a fair trial if this is published. And I think, again, we have the same issue with the court, being in a position where you're having to make a reliability determination without the opportunity for this individual to be cross-examined. Also, I do think the fact this is a minor that completed this form does make it protected. He's also potentially a victim under the same theory that has been stated for Ms. Wright, and under the UCJA acts for the same reason, the UCJA rules for the same reason, these should be protected private court records, and private means it shouldn't be played to court and it shouldn't be played to the public through the media. So we would object to its admission, we would object to its publication, and we would object to its filming. Thank you.
Any final response?
Judge, let me address, well, there's two things here, right? Let me address first the 1102 statement. Judge, I believe again that this statement was gathered in compliance with Rule 1102B8. Just double check. The agent has explained that although Mr. Phillips is a minor, his mother was present, and that explains, I believe he said, the second signature on the form. With regards to publishing it, the 1102 statement, that is, Judge, we believe again, the presumption is this is a public record, and that it should be not only admitted but published here in court, and also published so that the media can record it. With regards to, well, do you want to address the 1102, and then I'll move on to the video?
All right, so we're staying focused on the 1102. Any final response, Ms. Nestor?
No, Your Honor.
All right, thank you. As it relates to the 1102 statement and to the state representative who is displaying it, could you scroll down? I can only see the top half of this. All right. And just go to the very bottom so I can look at the totality of it. This is 7.1. All right, based off what's before me on the State's Exhibit 7.1, I find that it is admissible under Rule 1102 and to the Utah Constitution, Article 1, Section 12, to that paragraph I have referred to previously, and so it is admitted into evidence. And Mr. Sturgill, remind me, were you requesting for it to be displayed? I'm, again, focusing on 7.1.
Right.
In
On
court.
7.1, Judge, with regards to the video, we believe it's admissible. It's been authenticated properly.
Hold on. I'm not talking about the video. I'm talking about
Right.
7.1,
Oh.
publishing it in the courtroom versus publishing it on to be captured by the media.
Because we think that the presumption is it is a court record. We believe that in its redacted form. We believe it should be published in all three areas.
All right, Ms. Nestor, any final thoughts?
No, Your Honor.
All right. I'm going to go ahead and grant the publishing of Plaintiff's Exhibit 7.1 in court, and that the media may capture that. Let's go ahead and do so.
Scroll up. Slowly scroll down.
All right. You may proceed.
Did you admit Exhibit 7.1?
It is admitted into evidence and it was
All
published.
right. Have you personally watched Mr. Phillips's video?
I have, yes.
Okay. And what does it depict?
It's a graphic video. Mr. Phillips was positioned towards the front of the crowd, and it does depict the moment that Mr. Kirk is shot.
Okay. And independent of the 1102 statement prepared by Mr. Phillips, you watching that video, do you recognize at least the location of this video?
I do. It's consistent with the event that Mr. Kirk was presenting at UVU on September 10th, 2025.
Okay. Judge, at this point, the state would move to introduce or would move to admit what's been marked State's Exhibit number 7. We would simply ask that it be admitted. We would ask, however, that it not be published beyond that.
Ms. Nestor.
Due to the graphic nature and the sensitive nature of the video.
All right.
So as to the admission, the same issues that we raised as to the 1102, we would raise as to the difficulty of authenticating when the individual is not here present, and all the same concerns that we raised about the 1102 itself, Your Honor.
Thank you. All right. Considering the,
I'm sorry, may I add one more? I apologize.
You may.
And also under Rule 403, we think it's more prejudicial than probative. and we would raise it for that reason as well.
Any final response, Mr. Sturgill?
No, Your Honor.
All right. And this is Exhibit 7, is that
7.
correct?
Correct, Exhibit 7, Judge.
All right, I will admit Exhibit 7 into evidence based off the foundation that's laid. The 1102 is tied directly to this, and so for admission purposes, it is admitted. I am not going to authorize publication in the courtroom or obviously through media, but I will have it played on my screen. And so I view it, and I just want to make sure, and please, counsel, given the graphic nature of it, please guard your screens because I believe we all should be viewing this. This is evidence, and I want to make sure that you all are seeing what I see to ensure that that is accurate and it's a fair representation of the exhibit that you are familiar with. So whatever you need to do, I'll give you a moment, and if you could just give me a thumbs up if you're ready to proceed. Again, I want to act in a way that is dignified in respecting the rights of all persons. And for those reasons, I just want to make sure we are safeguarding to ensure this is not captured. All right. To defense, ready to proceed? Yes, Your Honor. All right. To the state? Yes, sir. All right. Go ahead, and let's play Exhibit 7. Is there sound? There is, Judge. All right, let's make sure that, thank you. Thank you. That concludes playing of Exhibit 7. You may proceed.
Thank you, Judge. Agent Hull, any more video that you collected, or either you or another agent with the SBA?
Yes, we were able to collect video. TPUSA had a videographer, Visual Impulse, who was taking coverage of the event, and they provided video to us that they had captured on September 10th of 2025.
And do you know who or how that video was collected from Visual Impulse?
Yeah, Mr. Farnsworth originally provided, I believe, a flash drive to Lieutenant O'Brien with one of the local agencies. And a short time after that, on September 10th, he provided downloadable versions, electronic versions to Agent Mortensen. And an 1102 was collected from him on May 6th of 2026.
So an 1102 was prepared by someone with Visual Impulse?
Yes, Terrell
Okay.
Farnsworth was the individual that prepared it, and in preparation for this, I spoke to him personally regarding that statement.
And do you know what his association is with Visual Impulse?
I believe he's the owner-operator or the director of the company.
And then who collected that 1102 statement from Mr. Farnsworth?
It was Agent Mortensen who collected it.
Okay, and you know that because Agent Mortensen told you, or?
He provided it to me, and then, as I mentioned, I subsequently spoke to Terrell Farnsworth personally regarding his statement.
Okay. You got a chance to look at Mr. Farnsworth's 1102 statement?
I have, yes.
Okay. And again, does that statement include an advisory that any statement that he provided would be used at preliminary hearing in lieu of his live testimony?
Yes.
Did it also include a warning that a false statement would potentially be punished by a Class A misdemeanor?
It did, yes.
Okay. I'm going to have exhibited on your screen what's been marked State's Exhibit 8.1. Let me know when that comes up.
That's come up.
I think it's a single page, is it not?
I believe it is.
Go to the top screen. Go to the top screen down slowly. You see that, Agent Hall?
Yes.
You do recognize that?
I do, yes.
Okay, and again, that is what?
It's the 1102 statement that was provided to me, completed by Mr. Farnsworth from Visual Impulse, who is the videographer for TPUSA for the events that they do.
Okay. Judge, the state would move to admit State's Exhibit 8.1.
Ms. Nestor?
Thank you, Your Honor. At this point, we renew our objection. This is hearsay. This statement is hearsay. We have constitutional concerns for the reasons we raised in our standing objection. We also would like to cross-examine Mr. Farnsworth about whether or not and to what extent these videos may have been altered in any way. It is clear that clips were being made out of the larger videos because he sent, even his own statement says he sent larger videos, and this is just a small portion of them. So obviously someone made clips, and we don't know who, and we don't know how, we don't know what they did. And for those reasons and the reasons in our standing objection, we would object to the admissibility of it, and as well the, I don't have a redacted version of 8.1, but I assume there is one. There is personal information on this one. Do you have a redact? Okay, I don't have that one. All right. And we would object to publication just on our concerns for fair trial, the same issues.
Just read that.
Yeah, gotcha. Yep, I think so. Thank you. And for all those reasons, we would object to its admissibility, its publication, and its ability to be filmed by the media, Your Honor.
Ms. Nestor, I just wanted to check, did you get a copy of the redacted?
I was just handed it.
Okay, I just wanted to make sure that
right.
you had copies.
Thank you, Your Honor.
So, okay, thank you. Mr. Sturgill, would you like to respond?
Sure, Judge, thank you. With regards to the admissibility of the statement, Judge, I think the foundation has been laid that this statement was collected in compliance with Utah Rule of Evidence 1102, subsection B8. It constitutes reliable hearsay. It's a statement that's been made by a declarant that's written and it's under oath, or not under oath, but pursuant to a notification of the declarant that a false statement made is punishable. I think there's been foundation to support that. In addition, Judge, Article 1, Section 12 of the Utah Constitution makes it very clear the state at preliminary hearing can rely upon reliable hearsay.
All right. Anything further before I make my ruling? Thank you. All right, applying the same analysis from the previous exhibits as it relates to the written statement under Rule 1102, and also under the Utah Constitution, Article 1, Section 12, in that last paragraph, I will overrule the objection and admit State's Exhibit 8.1. Let me hold off on that final phrase. If you could scroll down to the state representative and just stop right there. Thank you. I just want to make sure I fully review it before I make that ruling. And if you could continue scrolling down. And just go ahead and scroll down to the end. I don't believe there's anything else, but I want to make sure. Thank you. So I do rule that, overrule the objection, and State's Exhibit 8.1 is admitted into evidence and may be published. Well,
Judge, let me speak with regards to that. With regards to the 1102 statement prepared by Mr. Farnsworth in its redacted form, we believe that the presumption is this is a public record and that it should be published both here in court and made available to the public by virtue of the camera.
Ms. Nestor.
I just stand on the objection I made before, Your Honor.
Thank you. All right, looking at the same analysis, it is admissible under Rule 1102 as well as Article 1, Section 12 of the Utah Constitution, and being that the person's identifying information is redacted and not viewable, I'm going to overrule the objection, the standing objection, and have it published both in court and maybe published by the media. So let's just get it situated. And what I'll have you do to the representative of the state, pause on this screen and then in 10 seconds scroll down to the full text portion, and then 10 seconds later just slowly scroll to the remainder of the document. Thank you. All right, you can continue.
Thank you, Judge.
Well, hold on, she's still
Oh.
going through it. She's going to show
You were
the whole
talking to me.
document. Well, I should have clarified. Thank you. All right, and that concludes State's Exhibit 8.1, the publication of that document. Mr. Sturgill.
Judge, thank you. I appreciate that. Agent Hull, have you personally, so the video that's referenced in Mr. Farnsworth's 1102 statement, have you watched that visual impulse video?
Yes.
And what is depicted in that video?
It's a view from the cameras that Visual Impulse had established at the event, actually looking out from the stage into the crowd. It too is graphic in nature and shows the moment that Mr. Kirk is shot.
Okay. Does it also show Mr. Kirk throwing hats out into the crowd? Do you recall?
If my recollection serves, Mr. Kirk used to do that at the beginning of his events, and I believe the video does show him engaging with the crowd prior to becoming seated on the stage.
Okay. Judge, at this point, the state would seek to admit what's been marked State's Exhibit 8. With regards to publication, Judge, it's our position that it not be published here in the courtroom and that it not be published so that the cameras can display it.
Thank you, Mr. Sturgill. Turning to Ms. Nestor.
Your Honor, we would just renew our objections to authentication for admissibility purposes under 901 for the reason that I mentioned in the 1102, which is, you know, someone prepared these clips. We don't know who. We don't have that person here to cross-examine in terms of what, if anything, was edited. And for that reason, we think it can't be authenticated, and we object to its admissibility and our standing objection for constitutional grounds.
Thank you. Just one moment here.
Judge, would you like me to respond?
Yes, please.
Just with regards to authentication, again, the state must produce evidence sufficient to support a finding the item is what the proponent claims it to be. And again, under subsection B1, it's sufficient to provide testimony from someone that has firsthand knowledge or observed, has firsthand knowledge regarding the authenticity of that video. You heard Agent Hull testify that he spoke to the owner of and the director of Visual Impulse, I believe it was testified to, that they contract with TPUSA to film their events. This particular video, the state is going to, or seeks to introduce as Exhibit 8, was shown to Mr. Farnsworth. And that is the video that Mr. Farnsworth authenticates and says that this is video that was captured by Visual Impulse cameras. And so with regards to authentication, I think the state has sufficiently provided the court with evidence to authenticate it.
And this is State's Exhibit 8. All right. I'm going to overrule the objection and admit State's Exhibit 8 as it relates to publication, citing to Article 1, Section 28, 1A, that this is Declaration of Rights of Crime Victims, and it states to be treated with fairness, respect, and dignity. And to those 2 points of respect and dignity, the court is not publishing this in the courtroom, nor is it being published, obviously, online. But the court will watch it in court. And again, to the parties, if you could protect your screens however you choose to, and then I'll check to see when we're ready, and then we'll have it played. So turning to defense, is more time needed to? Okay, thank you. Turning to the state, to your screens. All right, all right. I see a head nod, yes. And let's go ahead and play this video only on the monitors, and if there's sound associated with it, the sound to be played as well. You may proceed. And that concludes State's Exhibit 8. Mr. Sturgill, you may proceed.
Thank you, Judge. So any additional video that was collected by either you or another member of the SBA?
Yes, the campus itself, UVU, is very well equipped with cameras throughout, and they were willing to work with us to provide video from those cameras, and so that was collected as part of the investigation also.
With regards to the UVU surveillance video, do you know if video was collected from there behind where Mr. Kirk was seated at the time that he was shot?
Yes, I'm aware that under the Hall of Flags there is I'll refer to it as a breezeway, but a way for people to move from one side into the amphitheater, walking underneath the Hall of Flags, and I know there was a camera situated in that location.
Okay. And do you know, with regards to that camera view, well, let me ask you this. So that particular camera view, there was surveillance that was provided to you or another agent from UVU?
Correct.
Okay. And do you recall who provided that video to you initially and who collected it?
Initially, I don't know specifically for that video, but I know that whole process was overseen by Mr. Olson, who's responsible for that system.
Okay. Do you have a first name for Mr. Olson?
Curtis Olson.
I'm sorry?
Curtis Olson.
Okay. And do you know what Mr. Olson or Curtis Olson's position is at UVU?
I believe he's a director.
Right. Is it his job to basically gather and forward any video that's captured by UVU?
He has a long title, but I think it's Director of Infrastructure, but he is responsible for that system.
Okay. With regards to this particular video, the video from underneath the Hall of Flags, what, if anything, have you done with that video in preparation for today's hearing?
I went specifically to meet Mr. Olson, have him review the video that we had, and again, like with the others, I had him complete an 1102 statement for us describing his role and verifying the videos. I did that actually on July 2nd of this year.
July 2nd of this year?
Correct.
Okay. Give me just one moment.
Actually, I'm going to correct myself on that if I can refer back to my notes.
Okay, please, yes. Your notes, you have there with you again?
Yes.
And referencing them will help you refresh your memory?
It will, yes.
Okay, so don't read from it out loud, just look at it and let us know when you've refreshed your memory.
Apologies, July 2nd seemed a little bit too soon. It was June 24th when I met with Mr. Olson.
Okay. And you personally met with Mr. Olson?
I did, yes.
Okay. And did you personally review this particular video, or I guess the Hall of Flags video with Mr. Olson?
Yes,
Okay. And he prepared a written statement?
he did, yes.
And on that statement, was that a bureau-provided statement form?
It was, yes.
Okay, and on that statement, do you recall whether it includes an advisory that his written statement would be used in lieu of his live testimony?
It did, yes.
Did it also include a warning that if he provided a false statement on that form, that he could be punished with a Class A misdemeanor?
It did, yes.
Okay. Is there something displayed on your screen right now?
There is, yes. It says
Okay, it should
Exhibit
be-
12.3.
Yeah, it should be what's been marked as State's Exhibit 12.3. Do you recognize what that is?
Yes, it's the State Bureau of Investigation's 1102 statement completed by Mr. Olson.
Does it appear to be in the same condition as when you collected it?
It does, yes.
As the state would seek to admit what's been marked State's Exhibit 12.3.
Ms. Nestor.
Thank you, Your Honor. We would again renew our concern about hearsay and our constitutional concerns about that raised in our standing objection. Also, the concern is that the individual basically states they verified the recordings, but doesn't say how, doesn't say whether they viewed it, doesn't say whether someone else viewed it and told them, whether someone else viewed it and told someone else who told someone else who told them. There's just no explanation. We don't think it's sufficient to meet your reliability analysis, and we object to admission, and we also object to publication. This is for all the same reasons, Your Honor.
To the state.
Judge, again, the state's position is that this written statement was collected in compliance with Rule 1102, subsection B8. It is a statement collected with both the advisory and the admonition. From what we've heard from Sergeant Hull, this individual, Curtis Olson, is the person it's his job basically to handle this type of information and turn it over to law enforcement.
All right, I'll have, if the state representative can scroll through so I can review it in its entirety and just stop when the majority of that handwritten statement's visible. Thank you. Let me review that. And if you could scroll down to the bottom of the page. Thank you. All right, under the same analysis for 1102, under Rule 1102, as well as Article 1, Section 28 of the Utah Constitution, I'm sorry, that's the wrong one. Under Article 1, Section 12 of the Utah Constitution, that final paragraph, the court overrules the objection and admits State's Exhibit 12.3 as it relates to publication. Mr. Sturgill.
Judge, with regards to publication, and this particular exhibit, it's the state's position that the presumption is that it's a public record, and we would ask that it be published both here in the courtroom and that the cameras be allowed to capture it and publish it as well.
All right, Ms. Nestor.
Nothing additional, Your Honor.
All right, I note the standing objection from defense, and given in the court's previous analysis for other 1102s, The court is going to publish it both in the courtroom and so it can be captured by the media. What we'll do is the same thing. We'll start at the top, pause for 10 seconds, and go to this middle section, and we'll pause about 20 seconds because there is a little bit, it is more dense. And then we'll scroll down to the very bottom for about 10 seconds, and then that will conclude that. So it's now on screen, and let's go from there. All right, you can scroll down. Okay, if you'd like to scroll to the very bottom. Thank you. That concludes publication of this exhibit.
Thank you,
Mr.
Judge.
Sturgill.
Well, in Mr. Olson's 1102 statement, he references more than one video, does he not?
He does, yes.
Okay. So you, with regards to the Hall of Flags video, have you seen that particular video?
I have, yes.
Okay. And that video, what does it depict?
It's a view kind of looking what would be east, under the breezeway towards the back of the stage where Mr. Kirk was situated. It shows some movement behind the stage area, and I believe through the gaps you can see some of the crowd in the amphitheater.
I think I've neglected to do this twice before, so I'm going to do it right this time. Would you please bring up Exhibit 9 without question play? Tell me when you see something on your screen.
It's on my screen.
Okay. Do you recognize what's depicted in that still image?
I do, yes.
What is that?
It's the area underneath the Hall of Flags that I referred to as the breezeway.
Okay. And is this the beginning of the video that Mr.
It is, yes.
Okay, that Mr. Olson provided you?
Yes, yes.
Judge, the state would seek, the state asks or seeks to admit Exhibit 9. With regards to publication, this is another video that, due to its sensitive, the nature and the graphic nature of the video, we'd ask that it not be published here in the courtroom, nor published in any way that the media camera could capture it. And following your reasoning, Judge, out of deference to the victims and the victims' rights, to have this type of information protected.
Ms. Nestor.
Thank you, Your Honor. We would object on our standing objection grounds, constitutional issues in terms of the concern about Mr. Robinson's right to a fair trial. We agree it should not be published. We object to its admissibility.
Thank you. Based off my analysis that I apply independently to this exhibit, but it tracks with the previous exhibits, I find that it is admissible, and I will admit it into evidence. This is State's Exhibit, I believe, 9. Mr. Sturgill?
Play it.
No, hold on.
Oh, I'm sorry.
This is State's Exhibit 9?
Right, correct.
All right. As it relates to publication in the courtroom or by the media, again, citing to the Utah Constitution, Article 1, Section 28, 1A, it states to be treated with fairness, respect, and dignity, and to be free from harassment and abuse throughout the criminal justice process. I find that this does apply. And in respect and dignity and the human experience, I am going to not publish it in the courtroom, nor will it be broadcast, but the court will watch it in open court. And I note it is about, how long is this video?
3 minutes, Your Honor.
All right. Again, to the parties, if you could just indicate if your screen is obscure. Thank you, Ms. Nestor. And to the state, are your screens secure so they're not viewable? All right, thank you. Seeing Mr. McBride nod his head, we can go ahead to the state representative. Go ahead and play State's Exhibit 9. And if there's sound, if you could activate sound. I'm not sure if there is. All right, so all right, let's go ahead and replay it. Just wanted to clarify there is no audio, so let's go ahead and restart it. Thank you. State's Exhibit 9 has concluded. Mr. Sturgill.
Thank you, Judge. I'm going to ask you just a few questions with respect to that video and the very end of that video, which is State's Exhibit number 9. Throughout that video, you can see a banner. Do you recall seeing a banner that's hanging basically in the middle of that video?
Yeah, I believe that's the rear of the gazebo.
Okay, the rear of the gazebo?
Yeah.
And what gazebo are you talking about?
It's like a pop-up tent that Mr. Kirk was sat underneath while he was addressing the crowd.
Okay, so just really quick, just to be clear, where in relation to that banner that you see depicted in Exhibit 9 is Mr. Kirk?
Approximately dead center.
Okay.
He's on a stage, so he's slightly raised in relation to the bottom of that banner. And then he's seated in the middle of the stage, so approximately in the center.
And how many, if you know, what's the distance between the banner and then where Mr. Kirk is seated in front of that banner, if I'm understanding you correctly?
I don't know specifically. If I had to estimate, I would say 3 to 5 feet.
Okay, so close to that banner.
Yes.
Okay, I also believe towards the end of that exhibit, well, let me ask you this. If you know, what happened to Mr. Kirk immediately after he was shot?
My recollection is that Mr. Kirk's detail, his own security team, removed him from the scene whilst administering first aid, and they conducted what would be called a hasty transport to Timpanogos Hospital.
Okay, before you go any further, that Mr. Kirk being picked up by his own security, is that portrayed in the video? In Exhibit 9, I'm sorry?
It's kind of on the left side. You can see Mr. Kirk come around the left side of the back of that Kirk being carried down the left side of the video under that breezeway.
Okay. And then you said that he was, that there was a quick transport, is that the language you used?
A hasty transport.
Hasty transport, what does that mean?
Just they were trying to get him to medical care as quickly as possible, so I believe he was thrown into one of the team's vehicles and then transported to the hospital, as opposed to waiting for an ambulance.
And I think you already stated, but let's just be clear. Do you know which hospital he was transported to?
I believe it's referred to as Timpanogos Regional.
Okay. And do you know if he was treated there at the hospital?
He was, yes.
Okay. Do you know whether or not he was pronounced dead there at the Timpanogos Hospital?
He was, yes.
Okay. And how do you know that?
The medical examiner had an investigator that responded to the scene, and I spoke with him, and he informed me that he was at the hospital when Mr. Kirk was pronounced deceased.
Okay. And that the medical investigator that you spoke to, do you know the name of that person?
Bullock, I believe, Officer Bullock, but if I can refresh my recollection
If
specifically.
it'll help, if you have it in your notes, it will help you refresh your memory, go ahead and look at that. Again, don't read from it out loud.
It is Officer Bullock, yes.
Okay. And he is a peace officer?
He functions as a law enforcement officer, and he works also for the medical examiner as a death investigator.
Okay. Do you know whether Mr. Kirk was autopsied by the Utah Medical Examiner's Office?
Yes, an autopsy was conducted by the medical examiner's office.
Do you know when and by whom?
Yes, it was late into the evening of September 10th, or it may even have gone through into the morning of September 11th.
Okay. And do you know who
I'm going to
conducted that
refresh my
autopsy?
recollection because of the pronunciation, if you don't mind.
If it'll help you refresh your memory, that'd be great. Again, don't read it out loud, look at it, let me know when you've done that, and then we'll go from there.
Dr. Guajado, I believe is how it's pronounced.
Okay. You want to spell that last name?
Yes, Guajado.
Your Honor, if this is not personal knowledge, we object to the hearsay if someone told him all of this. I don't believe this individual was present at the autopsy, so we object to any testimony about the autopsy or what he was told about it.
Mr. Sturgill.
Well, Judge, if I could, I'll just simply lay foundation for the report itself. And I think this is all information that's included on the report.
All right, so as it hasn't been moved into evidence just yet, I'm not making a ruling.
I appreciate
If you
that.
wish to lay more foundation, that's certainly your choice.
So you are aware that the medical examiner's office did conduct an autopsy?
I am, yes.
Okay. And did you receive a report from the medical examiner's office?
I did, yes.
Okay. Detailing the autopsy that was performed?
Yes. Prior to receiving the report, myself and Agent Davis visited with the doctor.
Okay. You visited personally with the doctor that conducted the autopsy?
That's correct.
Okay. And then subsequent to that, and did you discuss the autopsy with the doctor at that point in time when you were meeting with him personally?
Yes, Agent Davis and I had a fairly in-depth conversation, yes,
And where did that conversation take place?
at the medical examiner's office.
Okay. Do you recall the date and time that personal visit took place?
I don't recall.
Okay. Was it
soon,
within
it was soon after, within a few days of the incident.
of the autopsy?
Yes.
Okay. And subsequent to that visit, did you receive a report from that doctor that you visited with?
We did, yes.
Okay. And that's the Dr. Guajardo that you're struggling to pronounce his name, is that fair
Yeah, I
to say?
apologize, but yes, that's who it
Okay.
is.
And the report that was sent to you, do you recall when you received that report?
I don't recall the specific date.
Okay. Have you reviewed that report?
Yes.
Again, you stated earlier that this is not the first murder investigation that you've worked.
Correct.
Okay. I take it this is not the first medical examiner's report you've received.
Correct.
Okay. Do the reports typically look the same?
Yes, they're in a standard format that the medical examiner uses.
Okay. And this report that you received
Yes,
from who you believe was the doctor you spoke to
yes.
that conducted the medical exam, was there anything peculiar about that particular report that stood out to you?
No, it appeared to be a standard form as used by the medical examiner when they send us reports.
Okay. On your monitor, Exhibit 11, I'm going to have displayed what's been marked State's Exhibit number 11, Judge, for identification.
Right?
And I believe there's 9 pages. So let me know when you see that on your screen.
It's on the screen.
All right. What I'd like you to do is just look at this as it scrolls down through the 9 pages and wait till we get to the very end. And if you need us to pause or stop or slow down, let us know. I want you to be able to look at all 9 pages. Did you get a look at that?
Yes, sir.
Okay. Do you recognize what that is?
Yes.
What is that?
That's the medical examiner's report of examination for Mr. Kirk.
Yeah, do you recall, you don't recall exactly when you received that?
I don't unfortunately remember the specific date when I received it.
Do you remember how you received it?
Then provided to us electronically.
Okay. Via email?
Sometimes via email, also on disk, compact disk.
Okay.
Or,
And does there appear to be anything in the exhibit before you? Has that report changed at all? Or does it accurately depict what you received initially from the doctor?
it accurately depicts it.
Does the state would seek to admit Exhibit 11?
Ms. Nestor?
Your Honor, this is an expert report without the expert being present, being offered by an individual who's not an expert in this field. If they're presenting him as an expert in this field based on the limited questions about his experience in seeing previous medical exam records, I'd like to voir dire him on his qualifications to opine about it. This is hearsay. It's highly technical. It should be presented only through an expert. It could never come in trial in any other way. We submit that it is hearsay. And to the extent they're going to ask this individual about any opinions about it, that would be improper. He's not qualified to do that. And furthermore, we just think that this is clearly falling under our constitutional concerns about the absence of our ability to be effective, to cross-examine, to question we can't even question the expert's experience or CV or anything that we would normally do to determine if this should even be accepted or considered by the court. And so we strenuously object to its admission and for all those reasons to its publication as well. There's some really personal things in there that should never be published that deal with Mr. Kirk's medical condition history, is the condition of his body. It shouldn't be published, Your Honor.
Thank you. To the state.
Judge, this is clearly reliable hearsay admissible under Rule 1102 of the Utah Rules of Evidence. I would direct you specifically to subsection B5. For purposes of, and I'm quoting the rule, for purposes of criminal preliminary examinations only, reliable hearsay includes, and subsection 5 specifically states medical and autopsy reports and records. Again, that is supported by Article 1, Section 12 of the Utah Constitution, which states that reliable hearsay can be relied upon at preliminary examination in whole or in part.
into the second part in regards to publication.
As far as the publication, Judge, we agree with Ms. Nestor. This is a document that does contain very sensitive information and information that Mr. Kirk's family would appreciate it not being published. And so although we seek to admit it, we'd ask that it not be published here in the courtroom, or that it be published in any fashion or way that the public can see it by virtue of a camera.
Ms. Nestor.
Your Honor, I just want to point out that even though 1102 has a provision about exams, I mean, the court still has the overarching mission under 1102 to make this reliability finding, right? And it's just completely in a vacuum being offered by someone who's a police officer. So again, we would just argue that you're just not, it's hampering you from making the analysis you need to make to admit it, and we object to it.
All right, anything further from the parties?
No, Your Honor.
No, sir.
All right, so again, relying upon the analysis on Utah Constitution, Article 1, Section 12, as it relates to reliable hearsay, and then turning to Utah Rules of Evidence, Rule 1102, B5, specifically notes medical and autopsy reports and records. The court is going to overrule the objection and admit State's Exhibit, I believe it's 11,
11, yes, sir.
citing to Utah Constitution, Article 1, Section 28, dignity portion, respect and dignity. It will not be published either in the courtroom or viewable on media by the camera for the reasons previously stated as it relates to the video. And so the court will receive it, and it is admitted into evidence. And that concludes that portion. Mr. Sturgill, is this a good point to stop to take our 15-minute afternoon break?
I think it'd be a great idea, Judge. I've just got one last question.
All
if I
right.
could,
You may.
with respect to the medical examiner's report. Agent Hull, in that report, does the doctor relate cause and manner of death?
He does, yes.
Okay, and in that report, what is the stated cause of death
It was stated as a murder.
and manner of death?
It was a gunshot wound to the neck.
I
me
object,
one
it's
second.
not stated as a murder. I believe it's stated as a homicide, which is an important distinction.
Judge, I'll go back and correct that.
All right, so I'm going to sustain, well, first of all, let me look at the report. I need to see that section. I need to be able to draw my own conclusion. So, okay, I see, Ms. Nestor, are you referring to page 1 of this report?
I'm sorry, Your Honor. Could you repeat that? I apologize.
As it relates to your objection for the misstatements, are you looking at page 1 of the report?
Yes.
All right. So I'm-
Your Honor, I also need to make an objection on the best evidence rule, too. Thank you.
All right. So I'm going to sustain the objection as it relates to the manner of death. It does not say murder, but in regards to the best evidence rule, again, under 1102 and the Utah Constitution, that it permits reliable hearsay, it is, State's Exhibit 11 is admitted. Mr. Sturgill.
Agent Hull, I'm going to ask you to look at the first page of Exhibit 11. No?
Yes.
You see that?
Yes.
Okay. So let me ask you again, and you can look at it.
Yeah.
And would you mind relating what the doctor reports as the manner of death?
Yes, I misspoke. It does say homicide.
And then the immediate cause of death?
Gunshot wound of the neck.
Nothing further, Judge. Well, at this moment, I think it'd be a great idea that we take a 15-minute break.
All right, we'll go ahead and go on break. We'll come back at 3:25 and resume with this witness at that time. Court is in a brief recess. Please be seated. Court is back in session. And noting the presence of counsel as well as all the parties, I believe we were continuing with the direct examination of Mr. Hull by Mr. Sturgill. Mr. Sturgill, you may proceed.
Thank you, Judge. So, Agent Hull, in addition to what you've already described, what, if anything else, did you do on the 10th of September 2025?
Primary focus was to identify the individual who'd been seen on the roof with the preliminary footage. And so there was a big effort to review as much of the video that we had available to us from both the public, but predominantly from Utah Valley University, in an effort to follow that individual both forward and backwards from the time of the shooting.
Okay. So if I understood you correctly, priority was to identify the shooter,
Yes,
and to that end, you started reviewing even more UVU video than you've already described?
correct, yes.
Okay. What, if anything else, either did you do or happened initially that helped you identify who that shooter was?
So there was hundreds of hours of video that was reviewed, but the predominant focus, again, was on tracking the individual from the roof, either after the shooting had occurred or trying to trace the steps of the individual prior to the shooting.
Okay.
And we were able to do that through a combined effort of individuals. And the focus was having people reviewing video identify people who could fit the original description of the individual that had jumped off the roof.
At that point, so at this point, approximately how many hours of UVU video do you think you personally had seen or watched?
Myself, maybe 10 or 20 hours of video, being called in to look at different camera angles and different views of individuals. But there was a large team of people reviewing video.
Okay. Reviewing video?
Yeah, from UVU.
Were some of them SBI agents?
Yes, correct.
And combined, how much video do you think you watched that first day on the 10th?
It would be in the tens or hundreds of hours of video was reviewed.
Okay. Did anything else come along that helped you identify who that shooter might be?
Eventually on the evening of the 11th, we received word from Washington County that an individual in that area had reached out to law enforcement and was wanting to turn themselves in for the incident at UVU.
Okay. And did you, at that point in time, did you receive a name from Washington County?
Yes, we did.
And what was that name?
Tyler Robinson.
What, if anything, did you do with that information, the name Tyler Robinson?
That information was given to our SIAC, or our State Information and Analysis Group, and they put together what would be called a workup. So they would look at driver's license records, DMV records to determine addresses, obtain pictures of individuals, and then any associated vehicles or things like that.
So was that done with Mr. Robinson?
It was, yes.
Driver's license record was pulled.
Yes.
Did that include, if you remember, or do you know, did that include a photograph of Mr. Robinson?
It did include a photograph of Mr. Robinson, yes.
How about an address and date of birth?
There was an address and a date of birth, and I believe a DMV record with an associated vehicle.
All right. And so that DMV record did include a vehicle that was associated with Mr. Robinson?
Correct.
Okay. Do you remember what the make and model of the vehicle was that was tied to Mr. Robinson?
The Dodge Challenger.
Anything else beyond that you remember?
It was silver in color, and I believe there were two registered owners of the vehicle.
Okay. And who were the registered owners?
Mr. Robinson and then his mother.
Do you recall whether or not a date of birth was included in that driver's license information that you got initially?
Yeah, I believe the actual driver's license record was shared, so it would have included a date of birth.
All right. With with Tyler Robinson's personal information, were you able to expand your search at all?
Yes, once we knew a vehicle that we were looking for and we had an actual image of the individual, then we were able to use that video footage to try and track that specific individual.
Okay, and I'm sorry, let me clarify. So when I said expand your search, I'm referencing the UVU surveillance video.
Yes, we were able to.
Okay. And were you able to identify in that expanded search, did you believe you located that challenger?
We did, yes.
Okay. Were you able to determine at what time or times Mr. Robinson visited the UVU campus on September 10th?
Yeah, we were able to establish that Mr. Robinson had been on campus approximately 4 times throughout the day, twice before the shooting, the time of the shooting, and then after the shooting later in the evening into the early hours of the 11th.
You said that you initially tracked the shooter forward and backward
Yes.
with UVU surveillance video.
Correct.
Okay. Did you do the same thing with that vehicle?
We did, yes.
Okay. Tracked it forward and backward?
Yes, using the UVU footage and additional information that was obtained, yes.
And I believe you said that in total, Mr. Robinson visited the UVU campus 4 times that day.
Yes, that's correct.
And let's just be clear, that's all based on UVU surveillance video. Is that fair to say?
That's correct, yes.
Okay. Have you reviewed what's been marked States Exhibit 12.1 for identification?
I have, yes.
Okay. And, well, before we go there, of the video that you have personally watched, does the video include the 10th and the 11th, or just the 10th?
The video I've seen includes the 10th and then a very small portion, I think, about 0:30 of the 11th.
Okay. And I think you said initially you watched about 20 hours of video.
Yes,
Since that time, have you watched additional video?
yes,
UVU surveillance video.
yes.
Okay. And who provided the UVU surveillance video to you?
It was part of the collection of videos that was provided by Mr. Olson and his team that we already discussed previously.
Okay. Of all the hours of video that you've watched, do you have an idea of how many hours include Mr. Robinson or his vehicle?
Just with UVU or in
Just with
total?
UVU, I'm sorry.
Just with UVU would probably be about 16 hours.
And let's be clear, this is someone you believe to be Tyler Robinson.
Correct.
And this person that you've identified as Tyler Robinson, that you've been investigating and that you viewed in the numerous hours of video from UVU, would you recognize that person if he were in the courtroom today?
Yes,
Is he in the courtroom today?
he is, yes.
Would you point him out and describe something that he's wearing?
Your Honor, we object to unduly suggestive in-court identification for constitutional grounds.
Do you wish to specify unduly constitutional? I'm trying to understand your objection, so I want to make sure I fully understand.
Your Honor, I think there's some, and I'll defer to Mr. Byrd if he wants to jump in, but I believe there's a long line of case law that says, and you ask someone to identify the defendant when they're the only person, sitting at the table with defense counsel, that's unduly suggestive and taints any future or past, well, definitely future identification. So we object to that happening in this fashion at this time.
Mr. Sturgill.
Well, Judge, Agent Hull has testified that he has watched numerous hours of video. Well, take a step back. He has looked at personal identifying information of an individual by the name of Tyler Robinson. He's looked at the driver's license record, and he's also looked at the DMV records and has been able to determine what car that person drives. He's also looked at surveillance video that he believes depicts this Tyler Robinson. And I've simply asked him if that person that he has seen, both in driver's license photos and the surveillance video, if that person is here in the courtroom today. And I don't know that that's unduly prejudicial or suggestive. It's the routine. I don't know of any other way to do it other than the way I just did it, Judge.
Well, I wanted to verify the format of the question. I remembered it in my mind, but to Ms. Nestor, was that an accurate portrayal of the question that was asked?
Yes.
Okay. Mr. Sturgill, anything further before I issue my ruling?
Well, no, other than, Judge, I believe it's worth noting that Mr. Robinson is in plain clothes. Well, he's in
Counsel,
plain
please
clothes.
approach the bench. All right. Based off of what's been presented in court, I'm not finding that particular question as previously posed as suggestive. I find for the purposes of this hearing only that in-court identification by Agent Hull of Mr. Robinson has been made. Again, this only relates to the preliminary hearing, and you may proceed.
Thank you, Judge. Agent Hull, have you reviewed what's been marked State's Exhibit 12.1 for identification?
I have, yes.
And where did you review that video?
It was provided to me. I reviewed it on my computer in my office.
Okay. And is that the first time that you've seen this particular video footage?
This particular version of the footage, yes.
Okay, so this particular version the first time, but have you seen the video that comprises, I guess, Exhibit 12.1?
I have seen the original videos, if that's your question, yes.
So what is State's Exhibit 12.1? How would you describe it?
I would describe it as a compilation of the video that we obtained from Utah Valley University during the course of the investigation that depicts the movements of the individual I believe to be Mr. Robinson moving around the campus on September 10th, 2025 into the morning of September 11th, 2025.
Did you prepare this video compilation?
I did not.
Okay, do you know who did?
Yes, Utah County Attorney's Office. I believe Ms. Durfler is the one that produced the video.
Okay. Do you know Ms. Durfler's first name?
Kimberly?
Okay. What, if anything, did you do to authenticate the video in this compilation?
I reviewed the video to make sure that it was a reflection of what I understood the original videos to show.
Okay. What, if anything else, did you do?
I reviewed it. I know that there was some zooms and some changes to the footage.
Okay. Did you meet with Mr. Olson with regards to this particular video?
Yes, this video was also part of that original meeting with Mr. Olson for the prior exhibit, yes.
Okay. So at the same time, you sat down with Mr. Olson and discussed the prior exhibit. And let's just be clear which exhibit that is. So I believe the 1102 statement that you gathered from him is Exhibit 12.3, correct?
Yes.
Okay, so at the same time that you gathered that 12.3, or that written statement that is State's Exhibit 12.3, you talked to him about this specific exhibit as well?
Yes, Mr. Olson was shown this exhibit.
Okay. And did he include that in that 1102 statement?
Yeah, I believe he specifically referenced the exhibit by name, stating that it was a true reflection of the footage from the campus.
Okay. And let's just go back to what you were stating earlier. to you, it appears to be a compilation of videos that you've already seen,
Correct.
that you received as a mass dump, I guess, for lack of a better term, of view video. Is that fair to say?
Yes.
Okay. And the exhibit 12.1, does it appear to be the same as the raw video that you've seen previously?
It does, yes.
Okay. Are there some minor, are there any added additions or anything different about this particular exhibit?
There are some portions of the video where a zoom is initiated, which wasn't a function of the cameras. I believe some specific individuals have been blurred from the footage, and I believe there are some red circles to show poignant information or individuals within the footage itself.
Okay. So other than the red circles, the blur, and the zoom, does it appear to accurately depict what you've seen in the raw video footage?
I believe so, yes.
On your screen, I'm going to have displayed an image. Let me know when you see it.
The image is there now. It's gone again.
Is it there?
We're back, yep.
Okay, we're back. So do you recognize what this is?
Yeah, this is the first frame of the video compilation that we just referenced.
Okay. And again, this video portrays what you believe is Mr. Robinson visiting campus that day?
Correct.
Okay, and is it throughout the day?
It is, yes.
And then I believe you said into the early morning hours of the 11th, is that right?
Correct.
Okay. Shows the state would seek, or would move to admit what's been marked State's Exhibit 12.1.
Ms. Nestor?
Your Honor, we have objections to its admissibility. This is a compilation video that was put together from a bunch of different sources by the county attorney's office. This individual did not create this compilation, can't testify to the accuracy of the actual materials that it was taken from. And furthermore, Mr. Olson himself is just referred to by Agent Hull. He specifically says people have altered these recordings. They've zoomed in when the actual recording isn't zoomed. They've added little circles to people they want you to pay attention to. They've blurred people's faces out. So, I mean, it's been clearly altered. And it's not, I mean, they admit it's been altered. So we have real concern about authenticity of it. Furthermore, this particular video should be protected. And so that deals with the admissibility factor. As far as the publication factor of it, the video should be classified as protected under UCJA 4-202.02 subsection 5. J is in jelly bean, and then little I and little double I, because this is going to interfere with the defense's ongoing investigation, with Mr. Mr. Robinson's ability to get a fair trial. This is basically putting together photos that are clear with photos that aren't clear, putting them all together in such a format that it makes the case that it's all one person. It would be extremely prejudicial for people that may ultimately serve on this jury to watch this video before this case goes to trial. We don't believe a proper foundation's been laid, which would make it admissible at this point. So the fact that it would be shown to the public would be extremely damaging to the ability to put on a defense at trial. And so we object to its publication both in the courtroom and to the media, Your Honor.
Mr. Sturgill?
Judge, Ms. Nestor is correct. This is a compilation of a series of videos. The videos, as Sergeant Hull has testified, to is a compilation of raw videos that he has received from Utah Valley University. And he has not only seen this video, but he has seen all the raw footage. And by his estimation, or according to his testimony, these are all videos that are accurate and they depict what the raw footage depicts, other than those minor additions. Judge, if you refer to Mr. Olson's written statement, it's Plaintiff's Exhibit 12.3. He too has reviewed this video, and he has also identified this video as being accurate with the exception of those additions. In his words, it's the zooms and the red highlights. They weren't part of the original recording, according to Mr. Olson. But other than that, as he states, the same as Agent Hull, these videos are accurate, and they were captured by UVU surveillance video.
Do you have a version of this video that does not have alterations, such as zooming or circling? My concern is that if the 1102 says what it says about the videos, these were the videos.
Right.
But then it was altered. And typically an exhibit which has been altered, and if it wasn't done by the person who supplied the 1102, that can become problematic. And so do you have a version of this exhibit that does not have the zooming in or the circling? Again, I don't know all the alterations that were made, but that seems to fall outside the 1102 because you don't have a person testifying 1102 saying, I made the alterations.
Right.
And so that's the concern of what Ms. Nestor was talking about as it relates to the state's evidence. I have that concern about those alterations. I don't know when they were made, what they were made, how much was done to manipulate the video. And I say manipulate to, not saying it in a nefarious way, but I don't know what the scope of that is and how much it deviates from what was the original form.
Well, Judge, to answer your first question, do we have a version of this particular video that has not been altered? We don't, not right now, not today. I guess there's a couple of things I'd simply like to point out, Judge, and that is that we have two witnesses who have watched the raw footage. And Agent Hull here today on the stand and Mr. Olson in the form of his written statement. They have both said that this video, with the exception of these alterations, accurately depicts the video that was captured by UVU surveillance video. Judge, I will proffer that those changes made to the video were not done by either. I know who that person is. We could actually call that person as a witness if that would cure that. And we're prepared to do that if necessary. But Judge, I think that our burden is to simply authenticate, what this is. And it is a video that, with only a few exceptions, alterations, that really don't change the substance of the video or the content of the video. They're accurate. They depict what the cameras captured on September 10th and the 11th. And we have two people who have seen that raw footage, and they've explained that's the only difference between what we have originally in the original videos and what you're seeing here today. And the additions, I will submit, Judge, were only added to make it easier to view.
All right. Anything further from the parties?
No, Your Honor.
All right, I'm going to go ahead and I'm sustaining the objection. Typically, when exhibits are admitted to the court, it is without alteration. If a party circles an exhibit, a photograph, that's not the original format, and I do not have the person who made the alteration, an 1102, to substantiate that. And what I have is the original video, and Mr. Olson saying, this is the video minus the alterations. And we have Agent Hull saying, this is the video and there are alterations, but I'm missing a link. And it may be minor, but in this type of case, I want to be thorough. And I want to make sure that what is minor is still important. And for those reasons, I'm going to sustain the objection and leave it to the parties on how you wish to handle the video in the future. I don't want to provide guidance either way.
Right.
But as it stands today, this exhibit, State's Exhibits 12.1
or
is
12.1.
not admitted.
Okay. Judge, could I have just one moment?
You may.
Agent Hull, you testified that there were 4 visits to campus that day.
Correct, yes.
And the first 3 visits, based on what you have observed, is your opinion that those videos were captured by UVU surveillance video, is that correct?
That is correct, yes.
Okay. The 4th visit, well, the 4th visit too was captured by UVU surveillance video, is that correct?
Correct.
Okay. Was there any other video that was collected, either on the 10th or the 11th, that you believe might be important or relevant to today's hearing?
There was a large amount of video that
Well,
was,
I'm going to be a little bit more specific. Was there, other than UVU surveillance video, was there any other video that you collected and subsequently gathered an 1102 statement for?
yes, we collected Ring doorbell footage from the surrounding neighborhoods.
Okay. Let me ask you this. Did that include video from a residence located at 680 West, 925 South Orem?
Yes, that's in the horseshoe area, yep,
Okay. That's in Orem
correct.
and close to campus?
It is, yes.
Okay. And what can you tell us about that video?
There was a Ring doorbell video that was provided that showed a vehicle consistent with the one we had identified as belonging to Mr. Robinson,
Okay.
parking in front of the residence across the street.
Okay. And what can you tell us about the timing and the timing of that parked vehicle?
If I recall, that vehicle parked approximately 0:38 hours on the morning of the 11th.
Okay. So 0:38 hours, what time is that to regular people?
Just after midnight
At 12:38 a.m.?
in the morning, yes.
Okay. So how did this video come to your attention that you're talking about, this doorbell or whatever?
This footage was obtained as part of the canvass of the area that was conducted as part of the investigation.
Were you able to identify the owners of that residence,
Yes,
where that video was collected from?
correct.
Okay. And do you know who it was collected from and by whom?
It was Mr. and Mrs. Noble. I believe Agent Davis collected the video directly from them.
Okay. And do you know what date it was collected?
If I can refresh from my notes.
If referring to your notes will refresh your memory, go ahead and look at that. Don't read it out loud.
I don't have the specific date, but I do know that myself and Agent Davis returned to the address as we had done with previous videos, and had the owners of the video verify that it was from their system. And we did have them complete an 1102 statement, which would be dated.
Okay. Do you know, so let's talk about this, what does this video look like?
It's a nighttime view looking from the front porch of the residence across the street.
Okay. And what about that video? Why was this particular video significant to you, or why do you think it was related to this case?
We know from the UVU footage that the person we believe to be Mr. Robinson had an interaction with law enforcement. And a short period after that, the vehicle comes to that house, and some additional evidence that was collected from cell phone data and things indicated that Mr. Robinson was in the area, and we were able to locate the footage of his vehicle on that Ring doorbell camera.
Or at least what you believe is his vehicle?
Yeah, the vehicle we believe to belong to Mr. Robinson, yes.
And is there something about this particular video and this I guess vehicle that was captured that leads you to believe that it was Mr. Robinson's vehicle?
Yeah, the vehicle has very distinct wheels. I won't say that they're wholly unique, but in terms of the video footage that we were reviewing, the wheels on the vehicle are fairly unique and stand out on the video footage.
And so again, this is video that you received early on in the investigation,
Yes,
and then in preparation for the preliminary hearing, you went back out and you met with someone about this video.
correct.
Who specifically did you meet with about this video?
Met with Mrs. Noble.
And what did you do with Miss Noble?
We did what we had done before. We had a specific file that we wanted, or files that we wanted her to verify. The footage itself is broken into, I believe, 10-second segments. So we had specific files that we had her view and confirm that they were actually from her system. Those were written on the 1102 as they have been before.
Okay, and who wrote those file names on this particular statement?
I believe it would be my handwriting on the 1102.
All right. What did you do next?
We had her view the videos and then complete a statement verifying the authenticity of those videos on an 1102.
Okay. Was this also prepared on a State Bureau form?
I believe this was on a State Bureau Investigations form, yes.
And in this particular form on which Ms. Noble provided her statement, does it have the advisory that it would be used in lieu of her testimony here today?
It does, yes.
Does it also contain a warning that if she gave a false statement, she would be punished, or it's punishable by a Class A misdemeanor?
Correct.
Okay. I'm going to have displayed on your monitor what's been marked State's Exhibit number 13 for identification. Let me know when you see that, would you?
I can see that.
Okay, and I'm going to have my assistant scroll through that slowly. Okay. Do you recognize that?
I do, yes.
What is that?
The 1102 that myself and Agent Davis collected from Miss Noble.
Okay, and does it appear to be in the same condition as when you collected it?
It does, yes.
This is a copy, right?
Yes.
Okay. And the personal identifying information appears to be redacted, is that right?
It has been redacted, yes.
Okay. It wasn't redacted when you collected it, right?
No, the original form was not redacted.
So other than the redactions, it appears to be in the same condition as it was when you collected it.
That is correct.
State would move to admit Exhibit 13.
Ms. Nestor?
I know we renew our concern about unconstitutional hearsay being admitted. We also have the same concerns about the fact that Agent Hull amended this himself, and there's no foundation as to when he filled that in, if it was before or after she signed it. And due to all those reasons, we object to its admission and object to its publication as well.
Mr. Sturgill?
Judge, again, it was collected in compliance with Rule 1102 of the Utah Rules of Evidence, specifically subsection B8. It's in writing, It's on a form. It includes both the advisory and the warning. And it was collected by Agent Hull. It's also collected in compliance and being introduced as reliable hearsay, which is lawful to do here in Utah under the state constitution, Article 1, Section 12.
Do you wish to lay more foundation about when the statement was written, whether it was before it was signed or not?
I can do that, Judge. I appreciate that, yes. Agent Hull, do you recall when you collected this written statement from Ms. Noble?
Yes, it was in April,
In April, do you know what day?
April 6th, I believe.
Okay. And you collected it, did you go to her home? I think, is that what you said?
Yes, myself and Agent Davis went to the residence.
Okay. And did you sit there while she prepared it?
I did, yes.
And did you witness her sign it?
I did, yes.
Okay. There's, at this point, I'd move to admit Exhibit 13.
All right, and to the state representative, could you scroll down? Okay. All right, pursuant to the Utah Rule of Evidence 1102 and Article 1, Section 28, Article 1, Section 12, which allows for reliable hearsay, I'm going to move it into, it's going to be admitted into evidence over the objection of defense. I note in particular that it states that I confirm that the above files were taken from our Nest doorbell videos and are accurate. And right before that statement is the notations that were allegedly made by Agent Hull. And so for those reasons, the court finds proper foundation has been laid and that this exhibit in its entirety is admitted into evidence. As it relates to publication, I will authorize publication in the courtroom and by the media if they so wish to capture it in that form. Again, following the same format, have it on that first portion of the screen for about 10 seconds and then scroll down to the written portion for about 15 seconds and then scroll to the very bottom to ensure that the full exhibit has been displayed. All right, that concludes the publication of State's Exhibit 13.
Okay. Thank you, Judge. The video that you took with you that day when you visited with Noble, or Miss Noble, had you previously, well, you've stated that the videos that you showed, the Nobles, were actually more than one video.
Correct,
Okay, and I believe you said they were like 10-second clips,
if I recall correctly. Yes.
short clips. Okay. And you showed Miss Noble all of those videos that are identified in that statement.
The ones shown on the statement were shown to Ms. Noble, yes.
Okay. Have you had a chance to review what's been marked State's Exhibit number 12.2?
Yes.
Okay, and when did you have a chance to review that exhibit?
I believe that was reviewed last week, I believe,
Okay,
with yourself.
okay. And does that video, is it a single video that you watched?
No, I believe it's 4 separate short videos.
Okay. And as far as, and I understand that, but as far as 12.2 is concerned, what does that exhibit consist of?
It shows the vehicle believed to be driven by Mr. Robinson arriving in front of the residence, an individual exiting the vehicle and moving away from it, followed by an individual returning to the vehicle and unlocking it. And then it shows the vehicle a short time later starting and leaving the area.
And those are the videos that you showed Miss Noble?
Yes.
Okay. What I have displayed on your monitor was Ben Mark's plaintiff's or state's exhibit 12.2 for identification. Let me know as soon as you see, should be a still image.
It's there.
Do you recognize what's depicted there?
Yeah, this is the view looking, what would essentially be west across the street from the Nobles residence.
Okay. At 12:38 a.m., I guess, or 0:38?
Yes.
Okay. And what is depicted in this? I think you've already described that. So, Judge, I would move to admit Exhibit 12.2.
Ms. Nestor.
Your Honor, we renew our objection to allowing in the evidence without the sponsoring witness. I do have some concerns because I'm not totally sure if this is a compilation, or if this is just one of the 1, 2, 3, 4, 5, at least 6 videos they took from the Nobles. So if we could have that clarification, I think that concerns me about authenticity, that I don't understand if this is just a portion or if this is the whole thing, or is this just all of them or none of them. And for those reasons, we object to the admission and to publication.
Thank you. Mr. Sturgill.
That's a good point. And I'll ask additional questions before I re-seek to admit it. Agent Hull, this particular video, you've described taking several videos to Ms. Noble and having her review them.
Yes.
Okay. This particular exhibit, 12.2, have you watched it in its entirety?
Yes.
Does it consist of either some or all of those videos that you showed Ms. Noble?
It does, yes.
Okay. And is it a single video? Is it a compilation, that is to say, or is it 4 different videos?
It would
Or a number of different videos?
be a number of short videos sequenced.
Okay. A number of short videos in sequence?
I believe that's how this one plays, yes.
Okay. Just again, I seek to admit it.
Anything further from the parties? All right. Given my previous rulings on exhibits, I applied the same analysis and find that State's Exhibit 12.2, I believe, is admitted over the objection and may be published in the courtroom and by the media, if so chosen.
Okay, so before we play this video, again, what is it that leads you to believe that this is Mr. Robinson's vehicle?
The shape of the vehicle can be clearly seen as it pulls up, and the distinctive wheels on the vehicle also.
And well, let's go ahead and play it.
Is there any sound associated with this?
There is, Judge, but it's night sounds. It's crickets chirping and.
Okay, I just wanted to
there's-
see if
what's
there
that?
was, I just wanted to see if
There's
there
nothing
was sound
violent.
or not. Okay.
Yeah.
All right, you may play the video.
So in the first part of that video, what do you see?
The vehicle we believe to be driven by Mr. Robinson pulling up and parking in front of across the street, but in front of the residence.
Okay. And then in the next video, what do you believe is displayed in that video?
There's an individual who gets out of the vehicle. You can hear the door close, and then that individual moves away from the front of the vehicle. There's actually 2 reflective panels on a dumpster, and you can see the individual past those reflective panels.
And in the last of those series of videos?
The second to last one, the individual comes back across those reflective panels to the vehicle, unlocks the vehicle and gets into it. And then in the last video, the vehicle is started and the individual drives away.
Just one moment, Judge.
Yes.
Judge, could we approach?
You may. Please be seated. Court is back in session. We ended with the parties, the attorneys discussing. How would we like to proceed?
Judge, I think I just have a couple of questions for Sergeant Hull. To finish out the day, I think we're in agreement that once we've sorted out these few questions, we're all in agreement that we want to break for the day. Is that right, Ms. Nestor? Well, sure.
You may proceed with your questions, and
Okay.
we'll take it from there.
All right. Agent Hull, I asked you earlier, after you had testified about all the video that you've watched, and video that you believe depicts Mr. Robinson from the UVU surveillance, and that combined with the driver's license and the DMV records, whether or not you believe that that person that you have seen in the video and on the driver's license record is in the courtroom today. And I believe your answer was yes.
Yes, that's correct.
And then I asked you if you wouldn't mind pointing him out and describing something that he's wearing. And I don't believe that I allowed you to do that.
Okay.
Would you do that right now?
Your Honor, just for the record, we would impose an objection based on the 14th Amendment for due process due to an unduly suggestive in-court ID. Also, we believe there's a lack of foundation establishing his ability to interpret the surveillance video. And based on that, we would object.
All right. I note that, well, to the state, do you wish to be heard on what was just stated?
Well, Judge, I think we had this discussion, and I think you ruled on that specific objection. And then after you ruled, I just neglected to come back and follow through with the question and the answer. That's my recollection of the bench meeting.
All right. I believe I stated for the purposes of this hearing that identification by Agent Hull of Mr. Robinson was made. I could be wrong, but
Well, and I just wanted to clarify that, Judge, because there was some question about whether that in fact did happen. And so if that's your recollection of what happened, and if you're willing to put on the record that Agent Hull has identified the defendant, I think we're done.
Does the defense want to be heard?
Just a moment, Your Honor.
Of course.
No, Your Honor.
All right, well, if, for the benefit of the record and for thoroughness, if you wish to re-ask that question, you certainly, well, we can see what happens.
If I could, Judge, I'd like to. Would you please point him out and identify something that he is wearing?
Yeah, I believe that Mr. Robinson is between Ms. Nestor and other counsel wearing a gray suit, jacket with a dark tie, and a light-colored shirt.
Judge, I would ask that the record reflect that Agent Hull has identified the defendant.
I have no, I mean, I made my objection already.
Okay, I just wanted to check.
No, thank you,
All
Your Honor.
right. For the purposes of this hearing, I find that Agent Hull has identified Mr. Robinson. Again, this is only for the preliminary hearing. You may proceed.
Judge, I think for today, with Agent Hull, we're done for today. We'd ask that at this point we take a break until tomorrow.
All right, so are you saying that you're going to recall Agent, well, we're going to
let me-
resume with Mr. Hall tomorrow morning?
Tomorrow morning, and let me explain and I was going to explain this, but let me explain why. Judge, our intent is to prepare an original version of the video that has been in dispute today, without the circles, without the blur, and without the zooming in. And our intent is to introduce that tomorrow as a different exhibit. And we just can't prepare that in the next hour or so. So we're going to need this evening to prepare that exhibit. And we'd like to return with that. Judge, what I would also suggest, well, let me get your take on that, Judge.
All right, does the defense wish to be heard about ending for the day? We have about 19 minutes until 5 o'clock. What is the defense?
Your Honor, we're happy to accommodate the state on that.
All right. So for today, Agent Hull, you may step down, and we'll resume with your testimony tomorrow morning. Anything further, Mr. Sturgill?
Well, Judge, just one other thing, and it's a suggestion.
Agent Hull, can you wait just 1 second? I'm sorry. Go ahead.
I'm sure Ms. Nestor may have a position with regards to this, but Judge, we would invite you to review the exhibit that we've been talking about today. It is 12.1. We suggest that you look at it between today and tomorrow, because our intent is to seek to admit the version where it doesn't have the circle or the blur or the zoom in, and if that is admitted, we do intend to introduce that Exhibit 12.1 as well. And I think it would be helpful if you saw that in advance, and you could compare that to the version that doesn't have the circle, the blur, and the zooming in. I would ask that you do that. I don't know if Ms. Nestor has a different opinion about that, but I think it would be helpful in determining whether or not that particular exhibit, 12.1, is admissible.
Ms. Nestor.
I don't have anything to add to that. I defer to what the court prefers to do on that. I do have another matter before Agent Hull is released that I do want to address with the court, but I don't have any concern if the court wants to look at it in advance. It's kind of a little bit of a long video. I think it's just about 5 minutes, maybe. It's not very long. So if you want to wait until tomorrow, it's not going to slow the matter down very much, but it's up to the court on that.
All right, I appreciate the parties. What I'm going to do is I'm going to wait until it's properly before me and a motion has been made for either of the videos, and then I'm happy to entertain the motion to review both of them. or however the parties, I don't want to issue a pre-ruling, so I'll wait till it's properly before me, and I can take it from there. Being that it's about 5 minutes, I'm not too concerned about how much time is needed. I also want to be thorough, so I'll wait till it's brought before me and we can address it from there. And turning to Ms. Nestor as it relates to your request.
Thank you, Your Honor. Your Honor, I recognize that Agent Hull is the case agent and is working with the state in preparing for this, but he is still on the stand, and I would ask that he be instructed that he can't discuss his testimony, even though he's the case agent. I don't think it's proper for him to discuss his testimony while he's excused for the night.
Mr. Sturgill.
It's not a problem, Judge.
All right, so Agent, from this moment on until we come back in court, you're instructed not to discuss your testimony with anyone, as you are still on the stand for all intents and purposes. And we'll, if the state recalls you this tomorrow morning, then we'll proceed, okay?
Okay, Your Honor.
All right, may this witness be excused. For today. All right, thank you, Agent Hall. Anything further from the parties, or do either party need the benefit of the record before we adjourn?